You're watching Bloomberg Law. I'm Pacchia. Earlier this week, the United States Supreme Court struck down 3 out of the 4 provisions of a controversial new anti-immigration law in Arizona known as SB 1070. Here to fill us in on what this all means, we're joined again by Careen Shannon. She's an attorney at Fragomen. Thank you for coming back.
Thank you.
So we have a lot to work through here. 4 provisions, 3 knocked down. So what did we knock down? The measures that made it illegal for undocumented immigrants to work or reside in Arizona, that got thrown out. Any illegality for not carrying papers as an undocumented immigrant, that got knocked out. And also the provision that allowed warrantless arrests of undocumented or people suspected of being in violation of federal immigration laws, that was also struck down. The only thing remaining at this point is the so-called show your papers rule. That was allowed to stand. Were you surprised by this ruling?
I was somewhat surprised because there are actually 2 show me your papers provisions, one of which was knocked out, the one you just mentioned, that allowed warrantless arrests of people who are suspected of having committed some act that would make them removable. That was actually more egregious in many ways in terms of showing your papers to authorities, and that one was struck down. The fact that 2B was upheld is not exactly a resounding victory for Arizona, though. And notwithstanding Governor Brewer's valiant attempts to style it as a great victory for the state, the court did not definitively hold in any way that that is necessarily constitutional. All it did was say that it was premature to enjoin it on the current facts, that because it had not yet been implemented, it was premature for the court to determine before state courts had had a chance to construe it or local law enforcement had had a chance to implement it, whether it would implicate any civil rights or constitutional concerns.
So this is interesting. How do you expect Arizona to react? I mean, essentially now the Supreme Court basically put them on notice to say that they're being watched as to how they implement 2B. Ball's in their court. What do?
Well, they definitely were put on notice, and the court made it very clear that they expect further litigation on this issue. I mean, it seems to me that it's almost impossible to implement that section without engaging in racial profiling. That, of course, is what everybody's worried about. I mean, how do you determine if somebody who you've stopped for some other lawful reason, like running a red light or whatever, how do you determine if you have reasonable suspicion that they're undocumented? You probably wouldn't ask somebody named Shannon for her papers, but you might ask somebody named Gonzalez.
Right.
You might not ask somebody with white skin, but you might ask somebody with brown skin. You might not have reasonable suspicion if somebody speaks perfect American English that they're undocumented, but if they speak with an accent, you might. Those are all difficult issues. That's racial profiling in a nutshell.
Right. When we had you on the program before, we were talking about how, in totality, the 4 provisions of SB 1070 put a tremendous burden on law enforcement. It's just hard to carry out. It's hard to do it correctly. 2B by itself, does that alleviate some of those concerns, or is it just back to square one if you're a police officer in Arizona?
In some sense, it's back to square one. I mean, I should back up a little. This section doesn't actually give law enforcement any powers they didn't already have. They could already question people about their immigration status, seek confirmation from the federal government about somebody's immigration status if a person was lawfully stopped. What this section does is make it mandatory, which it was not before. But it doesn't give them any new powers. But overall, I want to paraphrase Tom Sines from the Mexican-American Legal Defense Fund, who issued a statement on Monday who said this is basically a kind of report card on Arizona's conduct in this area so far. If you had a kid who brought a report card home with 3 Fs and an incomplete,
right.
along with detailed statements, right, or statements indicating that the incomplete could very well become an F if you're not careful, that's not exactly cause for celebration.
So before this case got to the point where it was argued and ultimately decided, we were seeing a lot of people who were undocumented leave the state of Arizona. It had a tremendous effect on the economy there. Does this ruling change the internal calculus that those people that left the state would have to go through in order to make that decision? I mean, does this make it easier for them to return and resume the lives that they had in Arizona prior?
No, probably not. I mean, even though I'm saying I don't think this was a great win for Arizona, I don't think Latinos in Arizona are celebrating either, because they are still subject in the course of their daily lives to potentially having their immigration status scrutinized. I mean, I think the roads in Arizona may become the safest in America soon, because if you run a red light or you have a broken taillight or you're a pedestrian stopped for jaywalking. Those are all things that could happen very easily to any one of us. I mean, I jaywalk all the time here in New York City. That's a lawful reason to stop somebody, and that then gives police the opportunity to check your immigration status. So I don't think that the Latino population, the undocumented population in particular, is going to take much comfort from this ruling.
What does this ruling mean for other states that were trying to enact similarly aggressive anti-immigration laws? We've seen a couple of states enact stuff like this. Alabama comes to mind first and foremost. Where does that put them today?
Well, there are a number of states that have enacted copycat laws. Utah, Indiana, Georgia, South Carolina, and Alabama most famously, because theirs went further than Arizona's. I think this is a big stop sign. I think this is telling state legislatures these laws, for the most part, are going to be held unconstitutional. And even the part that was not struck down, there's still a lot of question about it. The Alabama law has a similar provision allowing police or requiring police to question people on their immigration status if they're lawfully stopped or detained. And that's already in effect. That was not enjoined in Alabama. So they've already been engaging in those acts in the state of Alabama. But as for the rest of that law and the other laws, I think it is a big stop sign. And in fact, there haven't been any other similar copycat laws enacted in 2012. So I think the tide was already turning.
So do you expect legislatures to kind of use this as an opportunity to maybe start repealing some of the laws that they put out there? I mean, what do? They're kind of stuck betwixt and between here.
Yeah, I mean, I think we may see some efforts, and we've already seen some efforts at repealing these laws. They may get more traction now, and given that it's an election year and it's such a touchy issue, I don't think legislatures are going to really touch these things one way or the other for a while.
And ultimately, we're talking about a lot of costs here. I mean, in economic terms, a lot of people are forced to leave the state. That has a negative impact on the economy, depending on who you ask, of course. But also, litigating cases like this all the way up to the Supreme Court and ultimately losing, that can be expensive, I would imagine.
Oh, yeah. I mean, Arizona has already lost hundreds of millions of dollars in tourism. They spent millions of dollars in legal fees. There's another case that will now make its way to the Supreme Court, I promise you, that was held in abeyance pending this decision, that is focusing on the potential civil rights abuses that could occur through racial profiling based on the section that was not struck down. Arizona's got to bear the cost of that. So it's a big nut they've taken on.
This still leaves us in a position as a country where a lot of people are unhappy with the national immigration policy we have and the way it's enforced. Do you expect Congress to act and come up with additional legislation governing the way that immigration is handled?
The gridlock that we've seen on this issue in Congress, I don't see that ending anytime soon. Congress couldn't even pass the DREAM Act, which you would think would be the least offensive reform of the immigration laws, allowing children who were brought here, through no decision of their own, who've stayed in school or served in the military, to become permanent residents and eventually citizens. Congress couldn't even pass that. I think there's little hope for comprehensive immigration reform anytime soon.
Careen, I want to thank you so much for coming in today.
Thank you.
That's Careen Shannon, attorney at law firm Fragomen, based here in New York City. If you'd like to learn more about the cases and issues we just discussed, be sure to check out our offerings on BloombergLaw.com and also on the Bloomberg Terminal. You can see more of our videos on YouTube, and you can follow our updates on Twitter. I'm Pacchia. Thanks for watching.